Be ready. 5 seconds. Start. This appeal by special leave questions the legality of judgment dated May 15, 2008 rendered by Division Bench of High Court of Delhi in Criminal Appeal number 183 of 1992, by which judgment dated September 29, 1992 passed by the learned Additional Sessions Judge Delhi in Sessions Case number 100 of 1989, convicting the appellant under Section 302 IPC and sentencing him to rigorous imprisonment for life and fine of rupees 2000 in default. Rigorous imprisonment for 1 year is confirmed. Stop. The facts emerging from the record of the case are as under. Stop. The marriage of deceased Shashi was solemnized with the appellant on January 30, 1982. Stop. After marriage, the deceased started living with the appellant at his place of residence situated at Chandigarh. Stop. During the subsistence of the marriage, the deceased gave birth to a girl child on January 2nd, 1983 at New Delhi, Para. Thereafter, the deceased went to Chandigarh to reside with the appellant. Stop. On April 4, 1983, the appellant with his wife and child came to Delhi from Chandigarh. Stop. After visiting the parents of the appellant, they went to the house of the parents of the deceased and took dinner there. Stop. After taking dinner, the appellant and the deceased with the child returned to the house of parents of the appellant at about 11:30 p.m. and retired to bed. Stop. At about 2:30 a.m. on April 6, 1983, shrieks of the deceased were heard and she was found engulfed in the flames. Stop. At about 2:45 a.m. on the night intervening between April 5 and April 6, 1983, the deceased was admitted to Lok Nayak Jai Prakash Narayan Hospital, New Delhi, with burn injuries. Stop. The duty constable posted at the said hospital sent a telephonic message at about 3 a.m. that Shashi, aged about 26 years, with burn injuries sustained in her house, was admitted by her husband, that is, the appellant. Stop. Para. This message was recorded at DD number 6A. Stop. On receipt of the message, ASI Hans Raj along with constable went to the hospital. Stop. He collected MLC of injured Shashi, wherein it was mentioned that the injured was got admitted at 2:45 a.m. by her husband and Dr. S.K. Bindal. Stop. It was also mentioned therein that the accident occurred due to the exploding of the stove. Stop. It was further mentioned in the said certificate that her clothes were smelling of kerosene oil and she had received extensive burns all over the body and face. Para. As per the endorsement recorded on the MLC, the injured was declared unfit to make statement at about 4:30 a.m. and 11 a.m. on April 6, 1983. Stop. Under the circumstances, ASI Hansraj recorded the statement of the appellant in the hospital, wherein the appellant claimed that at about 2:15 a.m. his wife Shashi had got up for boiling the milk for their 3 months old child, and he had got up from the bed on hearing her shouts stop. In his statement, the appellant mentioned that he immediately rushed and found his wife Shashi in flames in the kitchen, and that her clothes had caught fire while Shashi was boiling the milk on the stove. It was also mentioned by the appellant in his statement that he had received burn injuries on palm when he had made attempt to extinguish the fire to save his wife. Stop.